Your timesheet shows 40 hours this week, which is what we approved. That's what Stephen Walsh, our operations director, said when I asked him about the 53 hours I'd actually worked during a critical product launch week in November 2022, standing in his office doorway while he reviewed my submitted timesheet with the casual dismissiveness of someone who believed overtime approval was management's discretion rather than an employee's legal right to compensation. 40 hours, which is what we approved. I'd been senior production coordinator at Meridian Manufacturing for 10 years, managing production schedules and workflow coordination for our automotive parts facility that ran 2 shifts producing components for major vehicle manufacturers, working whatever hours were necessary to keep production lines running and shipments going out on time because that's what the job required and what I'd been told was expected of salaried coordinators who were part of the management team. But according to Stephen, our operations director who'd joined Meridian 7 years earlier and had implemented a policy of reclassifying hourly production coordinators as salaried exempt employees to avoid paying overtime, my actual work hours didn't matter because my job title said senior coordinator, and the company had decided that coordinators were management personnel exempt from overtime requirements under the Fair Labor Standards Act. I'm Rachel Morgan, and I stood in Stephen's office at Meridian Manufacturing knowing that the 53 hours I'd worked that week would be recorded as 40 hours on my paycheck, that the 13 hours of overtime would simply disappear into the gap between what I'd worked and what the company would pay me, and that this same pattern had been happening for 10 years across hundreds of weeks where I'd worked far beyond 40 hours without receiving the time and a half overtime compensation that federal wage law required for non-exempt employees. 10 years, 2 months, and 17 days of working 50 to 60-hour weeks during production crunches, showing up at 5 a.m. when a machine broke down, staying until 8 p.m. when a shipment deadline was tight, covering weekend shifts when production coordinators called out sick, and being told that this was simply part of my salaried coordinator responsibilities rather than overtime work that should have been compensated at premium rates. I wasn't an executive who made strategic decisions about company direction or a manager with authority to hire and fire employees. I drove a 2014 Ford Focus with 167,000 miles on it and a collection of production schedule printouts in my trunk because I reviewed next week's workflow during my Sunday evenings to prepare for Monday morning meetings. I lived in a small house in a working-class neighborhood in Toledo with a home office containing binders full of production reports, quality metrics, and shift schedules that I'd maintained meticulously because coordinating manufacturing operations requires tracking every detail of when products move through the facility. My filing cabinet contained years of my personal work calendars where I'd noted my actual start and end times each day because I'd always tracked my hours even after Meridian reclassified me as salaried exempt, some instinct telling me that documentation might matter someday even though I didn't yet know how or why. The trouble had started in 2012 when Meridian Manufacturing, facing pressure to reduce labor costs from their private equity ownership group, had made a strategic decision to reclassify several categories of hourly employees as salaried exempt to eliminate overtime expenses. Production coordinators had been hourly employees earning approximately $18 per hour plus time and a half for overtime. Many coordinators regularly worked 50 to 55 hours per week, especially during busy production periods, which meant significant overtime costs for the company. Stephen Walsh, who'd been hired as operations director in 2015, had implemented the reclassification plan. Production coordinators would become salaried employees with titles like Senior Production Coordinator or Production Planning Specialist, and would be classified as exempt from overtime under the Fair Labor Standards Act's administrative exemption. The theory was that coordinators were performing administrative duties related to business operations and therefore qualified as exempt employees who didn't have to receive overtime pay. What Stephen either didn't understand or chose to ignore was that the FLSA administrative exemption has specific requirements. To be exempt, employees must, 1. Be paid on a salary basis of at least a certain threshold amount, 2. Have a primary duty of performing office or non-manual work directly related to management or business operations, and 3. Exercise discretion and independent judgment with respect to matters of significance. Production coordinators at Meridian didn't actually meet these criteria. We didn't exercise independent judgment on matters of significance, we didn't have authority to make policy decisions, and our primary duty was coordinating production workflow according to schedules and procedures set by actual management. But Stephen had reclassified us anyway. In January 2013, I'd been informed that I was being promoted from hourly production coordinator to salaried senior production coordinator. My hourly rate of $18.50 translated to an annual salary of $48,000 assuming a 40-hour work week. Stephen explained this as a positive change. I was now part of the management team, I'd have a professional salary position, and I wouldn't need to track my hours as closely since I was exempt from overtime. What Stephen didn't explain clearly was that this promotion meant I would no longer receive overtime compensation for the 10 to 15 extra hours I worked most weeks. In my first year as a salaried coordinator, I worked approximately 2,480 hours total, about 400 hours beyond the standard 2,080 hours that a 40-hour work week would total. If I'd remained hourly, those 400 overtime hours would have earned time and a half compensation of approximately $27.75 per hour, totaling $11,100 in overtime pay. As a salaried exempt employee, I received zero additional compensation for those 400 hours. The promotion had actually reduced my effective hourly compensation from $18.50 to about $15.48 per hour. I hadn't understood the full implications immediately. I'd trusted that Meridian's reclassification was legal and that my new salaried status was legitimate. Over the next 10 years, I continued working the long hours that production coordination required, arriving early when issues needed attention, staying late when shipments were behind schedule, working weekends when production crunches demanded it, believing this was simply part of my job responsibilities. But I'd also continued keeping my personal time records. Every week, I noted my actual start and end times in a personal calendar. I tracked the hours I worked, even though I no longer submitted hourly timesheets. Some part of me wanted documentation of what I was actually doing, even if I didn't yet know why that documentation would matter. By 2018, 5 years into the reclassification, I'd accumulated roughly 2,000 hours of uncompensated overtime. At my then current salary equivalent hourly rate of about $20 per hour, those 2,000 overtime hours should have earned time and a half compensation of $30 per hour, totaling approximately $60,000 in unpaid overtime wages. I didn't know these numbers yet, I just knew I was working far more than 40 hours per week without additional compensation. In 2020, during the pandemic, production demands at Meridian intensified. Automotive manufacturers had complex supply chain disruptions and were putting pressure on suppliers like Meridian to maintain delivery schedules despite operational challenges. Production coordinators were working 60 to 70-hour weeks coordinating between shifts that were running with reduced staffing due to COVID protocols. I was working 12 to 14-hour days regularly, often 6 days per week. In July 2020, during an especially intense production period, I worked 82 hours in a single week. My paycheck showed the same $923 that it showed every week, my $48,000 annual salary divided by 52 weeks. The 42 overtime hours I'd worked that week, which should have earned time and a half premium compensation of approximately $1,260, earned me nothing additional. I started researching wage and hour laws. I discovered information about the Fair Labor Standards Act, overtime requirements, and the exemption criteria that Stephen had used to classify coordinators as exempt from overtime. As I read the Department of Labor's guidance about administrative exemption requirements, I realized that production coordinators at Meridian probably didn't actually qualify for the exemption. We weren't exercising discretion and independent judgment on matters of significance. We were implementing production schedules, coordinating workflow, and solving operational problems according to established procedures and management direction. Real decision-making authority rested with Operations Director Stephen Walsh and Plant Manager Dennis Cooper, not with coordinators. In September 2020, I contacted an employment attorney named Maria Santos who specialized in wage and hour cases. I brought my 10 years of personal time records showing my actual hours worked. Maria reviewed the documentation and asked detailed questions about my job duties, decision-making authority, and level of independent judgment. After 2 hours of discussion, Maria gave me her assessment. Rachel, based on what you've described, you don't qualify for the administrative exemption that Meridian used to classify you as exempt from overtime. Your role is coordinating production activities according to schedules and procedures set by management, not exercising independent judgment on significant business operations matters. Meridian has been misclassifying you as exempt, which means they should have been paying you overtime for all hours over 40 per week. Your personal time records show approximately 4,200 hours of overtime during the past 10 years. At time-and-a-half premium rates, that's substantial unpaid wages. Maria explained that the Fair Labor Standards Act allows employees to recover unpaid overtime wages for up to 3 years prior to filing a claim, or 2 years in cases without willful violation. But Ohio state law had different provisions, and there were various legal strategies for maximizing recovery. She recommended documenting everything, gathering additional evidence about job duties and classification decisions, and considering whether other coordinators at Meridian might have similar claims for a potential collective action. Over the next 6 months, I carefully documented my job responsibilities, collected emails and work assignments showing the scope of my decision-making authority, and compiled comprehensive time records. I also quietly spoke with 3 other production coordinators, Jennifer Wu, Marcus Thompson, and David Ramirez, who'd all been reclassified as salaried exempt around the same time I had. All 3 had similar stories. They'd been told the reclassification was a promotion, they'd continued working 50 to 60-hour weeks without overtime compensation, and they'd never questioned whether the classification was legally correct. On March 15, 2021, I filed a wage claim with the Ohio Department of Commerce, Division of Labor and Worker Safety, alleging that Meridian Manufacturing had misclassified production coordinators as exempt from overtime and had failed to pay legally required overtime compensation. I also contacted Jennifer, Marcus, and David to let them know about my claim and to suggest they might want to consult with employment attorneys about their own situations. Now about 76% of you think I'm about to describe a quick settlement or immediate court victory, and you're wrong. Subscribe right now, because what actually happens is that wage theft cases move slowly through legal and administrative processes, companies fight claims aggressively to avoid establishing precedent, and it takes years of determined pursuit before justice catches up to employers who've been stealing wages systematically. After I filed my initial wage claim in March 2021, Meridian responded by denying the allegations and asserting that production coordinators were properly classified as exempt under the administrative exemption. Stephen Walsh and Dennis Cooper submitted declarations describing coordinator duties in ways that emphasized analytical decision-making and minimized the routine coordination work that actually comprised most of our responsibilities. The Ohio Division of Labor conducted an investigation from April through September 2021. They interviewed me, reviewed my time records, examined my job description, interviewed Stephen and Dennis about coordinator duties, and analyzed whether Meridian's exemption classification was legally supportable. In October 2021, the division issued preliminary findings that production coordinators at Meridian appeared to be misclassified and that overtime wages were likely owed. Meridian appealed the findings and requested a formal hearing. This moved the case into an administrative law process that would take additional months. Meanwhile, Jennifer, Marcus, and David had each filed their own wage claims, and Maria Santos began discussing with all 4 of us whether to pursue a collective action in federal court under the Fair Labor Standards Act that could potentially cover all production coordinators who'd been misclassified. In March 2022, 1 year after my initial claim, Maria filed a collective action lawsuit in U.S. District Court for the Northern District of Ohio on behalf of myself, Jennifer, Marcus, David, and all similarly situated production coordinators at Meridian Manufacturing. The lawsuit alleged willful misclassification of non-exempt employees as exempt, failure to pay overtime wages as required by the Fair Labor Standards Act, and sought unpaid overtime wages, liquidated damages equal to unpaid wages, attorney's fees, and court costs. Meridian hired an employment defense firm from Cleveland and began fighting the case aggressively. Their legal strategy was threefold. 1. Argue that production coordinators did qualify for administrative exemption based on the analytical and coordinating nature of the work. 2. Argue that even if misclassification occurred, it was good faith error rather than willful violation, which would limit damages. And 3. Challenge my time records as unreliable since they weren't official company records. The discovery process lasted from April 2022 through January 2023. Both sides requested documents, conducted depositions, and gathered evidence. Meridian was required to produce all policies related to coordinator classification, all communications about the 2012 to 2013 reclassification decision, all job descriptions and performance evaluations for coordinators, and all payroll records showing hours worked by coordinators who'd been reclassified. This discovery process revealed damaging evidence for Meridian. Internal emails from 2012 showed that the private equity ownership group had pressured Meridian leadership to find ways to reduce labor costs, and that reclassifying coordinators as exempt had been explicitly identified as a cost-saving strategy. One email from the private equity firm's operating partner stated, reclassifying production coordinators as salaried exempt should eliminate approximately $300,000 in annual overtime costs across the facility. Another email from Stephen Walsh to Dennis Cooper from January 2013 stated, "We need to be careful about how we communicate the coordinator reclassification. Emphasize the professional status and management team aspect. Don't mention the overtime implications or we'll have people questioning the change." These emails demonstrated that Meridian's leadership had been aware that the reclassification would eliminate overtime payments, had implemented it specifically to reduce costs, and had deliberately downplayed the compensation implications when communicating with affected employees. This evidence would support a finding of willful violation rather than good faith error. The discovery also revealed that Meridian had classified 16 production coordinators as salaried exempt between 2013 and 2022. Most had worked consistently over 40 hours per week. The pattern of overtime hours was remarkably consistent. Coordinators routinely worked 50 to 55 hours weekly, and during production crunches they worked 60 to 70 hours. Meridian had effectively gotten 10 to 15 hours of free labor per week from coordinators by simply not paying them for that time. Maria Santos calculated the total unpaid overtime across all 16 coordinators over the relevant time period. The numbers were staggering, approximately $2.8 million in unpaid overtime wages over 10 years. Under FLSA, if the court found willful violation, employees could recover not only the unpaid wages but also liquidated damages equal to the unpaid amount, effectively doubling the recovery. Total potential liability, $5.6 million plus attorney's fees and costs. In February 2023, the case reached the motion for summary judgment phase. Both sides argued about whether the material facts were disputed or whether the case could be decided as a matter of law without going to trial. Meridian argued that coordinator job duties clearly met administrative exemption criteria. We argued that the duties didn't meet the requirements and that Meridian's own internal emails showed they'd implemented the reclassification to avoid overtime costs rather than based on legitimate analysis of job duties and exemption criteria. On August 7, 2023, Judge Patricia Morrison issued her ruling on the summary judgment motions. The opinion was devastating for Meridian. Judge Morrison found that production coordinators at Meridian did not meet the administrative exemption requirements under the Fair Labor Standards Act. The opinion stated, coordinators' primary duty was implementing production schedules and coordinating workflow according to procedures and priorities established by management. While coordinators exercised some problem-solving judgment in addressing operational issues, this did not constitute discretion and independent judgment with respect to matters of significance as required for administrative exemption. The evidence demonstrates that significant business decisions regarding production priorities, resource allocation, and operational policies were made by Operations Director Walsh and Plant Manager Cooper, not by coordinators. Judge Morrison also found that Meridian's misclassification was willful. Internal emails demonstrate that Meridian's leadership was aware that the reclassification would eliminate overtime compensation and implemented the change specifically to reduce labor costs rather than based on legitimate analysis of whether coordinators' duties met exemption criteria. This constitutes willful violation of FLSA overtime requirements. The ruling meant that Meridian was liable for unpaid overtime wages for all affected coordinators, plus liquidated damages equal to the unpaid wages, plus attorney's fees and costs. The case would proceed to trial only on the issue of calculating exact damages for each coordinator. Between August 2023 and March 2024, the parties engaged in intensive settlement negotiations. Meridian wanted to avoid a trial that would generate additional publicity about their wage practices and that might result in even higher damages if the jury found their conduct particularly egregious. Maria pushed for full recovery of all unpaid wages plus liquidated damages for all affected coordinators. On March 22, 2024, the case settled. The settlement terms were, Meridian Manufacturing would pay $4.2 million to resolve all claims for unpaid overtime wages and liquidated damages for the 16 production coordinators who'd been misclassified between 2013 and 2023. Meridian would immediately reclassify all production coordinators as non-exempt employees eligible for overtime compensation. Meridian would pay $680,000 in attorney's fees and costs to the plaintiff's legal team. Of the $4.2 million settlement fund, my share was $847,000, representing 10 years of unpaid overtime wages plus liquidated damages. Jennifer, Marcus, and David each received between $520,000 and $670,000 depending on their years of employment during the misclassification period. The other 12 coordinators who joined the case received amounts ranging from $180,000 to $520,000. On April 15, 2024, I received my settlement check for $847,000. After taxes, I netted approximately $570,000. This was compensation for 10 years of overtime hours that Meridian had simply not paid me, hours I'd worked, hours I'd documented, hours that federal law said I should have been paid time-and-a-half rates for, but that Meridian had pretended didn't exist by classifying me as exempt from overtime. On April 16, I submitted my resignation from Meridian Manufacturing. I'd worked there for 12 years total. The settlement gave me financial security to pursue other opportunities without the stress of dealing with an employer that had systematically underpaid me for a decade. On June 3, 2024, I ran into Stephen Walsh at a local restaurant. He'd left Meridian shortly after the settlement, reportedly pressured out by the private equity ownership group who were furious about the multi-million-dollar wage claim payout. He was working as an operations consultant, trying to rebuild his reputation. He saw me and approached cautiously. "Rachel, I heard about the settlement. That was quite a result for you." I looked at him steadily. "It was compensation for 10 years of overtime hours you didn't pay me. Hours I worked while you kept telling me that's just what salaried coordinators do. Hours I documented in my personal records while you were editing my timesheets down to 40 hours per week." Stephen tried to justify his actions. The reclassification was a legitimate business decision based on interpretation of exemption criteria. My attorneys told me at the time that coordinators could qualify as exempt administrative employees. I responded, "Your attorneys might have told you that, but your internal emails show you implemented the reclassification specifically to eliminate $300,000 in annual overtime costs. And when the judge reviewed what coordinators actually did versus what the law requires for administrative exemption, she found you'd willfully misclassified us. That's not interpretation, that's wage theft dressed up as job titles." Stephen started to argue, but I continued. "You took 13 hours from me in 1 week in 2022 and paid me for 0 of them. You did that in hundreds of weeks over 10 years. You took overtime hours from 16 coordinators and simply didn't pay us because you'd decided we were a management team, members who didn't qualify for overtime." The court disagreed, and Meridian wrote checks totaling $4.2 million because you spent a decade stealing wages from people who trusted that their employer was following the law. Stephen didn't have a good response. He walked away. "Thanks for staying through this entire story. Everyone who's ever worked unpaid overtime hours because your employer classified you as exempt or told you that's just part of your salaried responsibilities, or who've watched companies systematically underpay workers through creative job titles and misclassification schemes. If this resonated with you, if you've ever suspected your employer was violating wage laws but didn't know how to fight back, subscribe and share your story. These workplace tales remind us that wage theft is illegal regardless of job titles, that documentation of actual hours worked can be powerful evidence years later, and that companies who systematically underpay workers eventually face courts that don't care about their cost-saving justifications.